In this lecture, we would like to discuss another most important landmark judgment delivered by the apex court or Supreme Court is relating to Maneka Gandhi versus Union of India, and the very particular case relates to Passport Act of 1967 and Article 21 of the Constitution relating to right to life and personal liberty, and particularly it involved the right to travel, whether it is falling under Article 21. So, according to the Passport Act of 1967, Maneka Gandhi's passport was issued on 1st June 1976. On 2nd July 1977, she got an order from the Regional Passport Office of New Delhi to surrender her passport. Also, she was not given any appropriate reason for this order from the External Affairs Ministry, and that is the very fact of the case. Maneka Gandhi then approached the Supreme Court by invoking its jurisdiction under Article 32 of the Fundamental Rights. She contended that the decision to surrender her passport was a direct attack on her right to physical liberty according to Article 21, which provides the right to life and personal liberty. It is pertinent to note that the Sadhvan Singh Sahani versus Ram of the Judgement, where Supreme Court held that right to travel is falling under the ambit of Article 21, although the right that extends to which the Passport Act diluted was unclear. So, the very issues involved in this landmark judgment is relating to Article 14, that is right to equality, and Article 19 of those fundamental freedoms relating to right to move freely, and Article 21 then the very right to travel and Passport Act of 1967. So, where the provisions or acts of Article 21, 14 and 19 related as they are mutually exclusive, does Article 21 contain the right to travel or not? Is the decision of the legislative law that snatches away the right to life is reasonable? Should the procedure laid down by the Passport Act of 1967 be checked for reasonability? So the arguments forwarded by the petitioners counsel regarding Article 14, 19 and 21, then procedure established by law and the very principle of natural justice and the provisions under Section 10, subsection 3 and clause C of the Passport Act of 1967 and the very principle of natural justice as explained under the maxim Audi Alteram Partem. So the decision to seize the passport on 4th July 1977 had infringed the petitioner's Maneka Gandhi's right to life and personal liberty, travel, freedom and freedom of speech. The provisions of Articles 14, 19 and 21 are not related and are not mutually exclusive to each other. They need to be studied together. Only on accumulative reading and appropriate interpretation will lead to observance of natural justice. As we know that the very American concept of the due process of law was not adopted by the Indian constitutional makers. However, the procedure established by law as adopted from the English legal system must be fair and safe. Also, they should not be arbitrary. And as under Section 10, Subsection 3 and Clause C, the Passport Act of 1967 violates Article 21 in so far as it violates the right to life and personal liberty as provided under Article 21 of the Constitution relating to fundamental rights under Part 3 of the Constitution. The opportunity of being heard, which is related to the very maxim ade Alteram Partem, is acknowledged as a significant component of the principles of natural justice, and those contentions of the respondent relating to procedure established by law as adopted from the English legal system and due process of law which is followed in the American legal system. So the respondent stated that the decision to surrender the petitioner's passport was that the petitioner had to attend the government committee for a hearing. The respondent stated that under Article 21 the term law could not be understood as given in the principle of natural justice, emphasizing the judgments of A.K. Gopalan. The respondent said that Article 21 contains the phrase procedure established by law and said that such a procedure does not need to pass the test of reasonability and should not be under Articles 14 and 19. This happened at long debate among the framers of our Constitution on adopting American due process of law versus the English or British procedure established by law. Also, the absence of America's due process of law in the provision of the Indian Constitution indicated the intentions of our Constitution makers. So, now we would like to discuss the very judgment delivered by the apex court in this important landmark judgment, Maneka Gandhi versus Union of India, on 25th January 1978. The judgment altered the Indian Constitution. It widened the scope of Article 21 and made the Constitution makers realize the goal of making India a welfare state. A 7 judgments passed this important judgment on India's legal and constitutional history. Now we would like to conclude our lecture on the very discussion relating to Maneka Gandhi versus Union of India, a landmark judgment delivered by the apex court in the year 1978. The judgment of Maneka Gandhi's case widened the very scope of Article 21 and personal liberty and preserved the fundamental right to life. This judgment interdicted the provisions of Articles 14, 19 and 21. Through this link, the provisions of Articles 14, 19, and 21 become inseparable and into a single entity. Now it had been become necessary for every procedure to meet all the requirements of all these provisions laid down under Article 14 as such relating to right to equality and Article 19 as such relating to those fundamental freedoms to the citizens of India and Article 21 which provides right to life and personal liberty as under the Constitution of India. So the judgment also brought more rights under the very ambit of Article 21 like the right to travel, right to clean drinking water, right to livelihood, right to clean environment and right to standard education and also the right of freedom from noise and etc. So the very ambit of Article 21 was expanded after this landmark judgment delivered by the apex court, as was the judgment of Maneka Gandhi versus Union of India, as delivered on 1978, which expanded the very scope and ambit of Article 21 of the Constitution, which relates to right to life and personal liberty.